So hello and welcome to Coproduce Care. Today we have the very knowledgeable Ruck Keene with us from 39 Essex Chambers. Alex is a barrister and specialises in mental health and mental capacity law. And so without further ado, I think we'll start our Coproduce Care chat. Firstly, welcome.
Thank you.
And if you could just let us know what you do, what your specialism is, and what your interest is in mental capacity law.
Thank you. Well, thanks so much for having me. I really do appreciate it. I'm a barrister in London, and I've been a barrister there for not quite, but nearly 20 years. And for well over half that time, I've been specialising in mental capacity law. And when the Mental Capacity Act came in 2007, that really became a primary focus of what I do. And I do a lot of work both in court and out of court relating to the Mental Capacity Act, and working around that area too. So when mental capacity comes in all sorts of different areas, and I've got a particular interest in in mental health law, so in particular where people with mental health conditions may have impaired capacity to make decisions, and so where mental capacity meets mental health law. Mm-hmm. So that's what I spend most of my time doing one way or another.
Yeah, so that's great. So I'm quite interested actually in the work that you do. So you obviously work with people who have cases coming up, but also you have a lot of engagement with the sector and with professionals and supporting them, as well as supporting the Law Commission that you've done some work with.
Yes. So, once upon a time, I did what most barristers do, which is go to court a lot. And the court I went to in the context of capacity is the Court of Protection. So I was acting, and I still do act every so often, for either the person, the subject of the proceedings, who's rather weirdly called P, which just means person, but it's an acronym, which I don't like because it depersonalises it.
So P is, just to explain that out, that P is the person with the capacity issue that professionals might have come to the court saying we need a decision that the court can make to decide whether this person has capacity or not.
Yes,
so,
and if they don't have capacity, what is in their best interests.
Yeah.
So I did lots and lots of cases in the Court of Protection, either acting for the person or acting for health bodies or social care bodies or other people before the court. And then I stopped. I still do cases, but I now do fewer cases, and I spend a lot of my time doing work related to the Mental Capacity Act outside the courtroom. Because a few years ago I took a decision that what I was really bothered about was mental capacity, and I didn't really mind whether I did it, as it were, advocating in a courtroom in relation to an individual person, a specific person, or delivering training to health and social care professionals, or writing about the law, or as you say, I was at the Law Commission for a period of time working on a piece of legislation amending the Mental Capacity Act. But it's all kind of organising principle around mental capacity. And I think one of the reasons I find I wanted to, as it were, take a slight step back from doing cases day in, day out, is that I think an awful lot of what goes on in relation to mental capacity law, you need to be informed by a wider understanding than just the very peculiar cases which come to court. They're incredibly important, but they tend to be there's something very, very specific. Whereas mental capacity is a concept that social care professionals apply hundreds of thousands of times a day in all sorts of different contexts. And one of the things I felt was important was to feel, to actually get to see how that was working in a care home or in a palliative care unit or in all sorts of different settings where people are having to think about it. And I got very bothered by the fact that a lot of professionals of all sorts of different kinds aren't legally literate and they aren't legally confident. So there's a legal framework, the Mental Capacity Act, which they may have heard of, hopefully they've all heard of, but they may not be familiar with it, may not be confident with it in applying it. And if they're not confident in applying the law, then actually things start going wrong quite quickly. And one of the things which starts going wrong is unless you understand the law, you then don't know how to apply it, and then what you're actually applying the law relates to all sorts of ethical dilemmas. Because one of the things I find fascinating about this area of the law is it's maybe 1% law, 99% ethics.
Oh, wow.
Because 99% of the time the question is, the law probably says you could. I could find this person to lack capacity to make this particular decision, and I could do this thing in their best interests. The real question is, should I?
Yeah.
And should is not something which is, the law doesn't tell you. The law gives you, as it were, the framework within which to ask the questions. And so I find it very, very interesting. I really enjoy hugely working with people from different sectors. I mean, I do a huge amount of work with, for instance, intensive care doctors or palliative care specialists or social workers, and seeing their skills, which I don't have. I don't have those skills. I've got other skills.
Yeah.
And seeing how their skills and how their values apply to difficult situations, and then coming along and saying, well, let's look at this problem together.
Yeah.
Let's think about this together. If I, as it were, lend you my legal thinking to think about how you might think about this, you lend me your, your social care values, your clinical values, and let's see, where we end up. And that, obviously, if you've got an individual case concerning an individual human being before the court, it's being applied in a very intense fashion, but it's sometimes a very specific fashion, and it's not thinking, as it were, more broadly.
That's so interesting. So I feel like we're going to start off talking a lot about the Medical Capacity Act.
Yeah.
So just for people who might not really know that it's out there, know that their relative has been tested for their capacity, but doesn't really understand what that actually means, could you just give a very brief overview of what the Act is and when it kicks in, when people have to apply it? Yes,
so the Medical Capacity Act came in 2007, so as this is November 2019, I'm just temporarily forgetting the date. As it's now November 2019, it's been enforced for over a decade. And really what it is, it's a piece of legislation which says what we do in circumstances where we think the person we're interacting with may not have the ability to make their own decision. So they may not have the ability in a medical situation to consent to a particular operation, or in a social care context they might not have the ability, even to do things like make a choice about their clothing, or about their eating, or about slightly more as well hardcore things like where they might live, should they stay in a care home.
Yeah.
And so there has to be, I think most societies recognise there has to be some regulation around that, some way in which to make sure that you don't, somewhere in which to regulate thinking about what happens. And so the Medical Capacity Act gives you the framework in two ways. One, it gives the framework for saying, how do I think about whether or not this person's got this ability to make this decision, the mental capacity to make this decision? And if they don't have the mental capacity to make this decision, what's the decision which is right for them, which is the best interest term that people use. But can I just absolutely emphasise and flag up, this is not an act about other people, in the sense of whenever I do training, if it's early in the morning, people need to move, I tell a third of the audience to stand up. Because a third of the audience are going to have, at least a third are going to have the Mental Capacity Act applied to them.
Oh, really?
Because, a third of people, the rate of dementia.
Right.
Someone will have been in a car crash.
Yeah.
Any of those situations where either temporarily, for instance, after a car crash, or on a longer term basis with the onset of dementia, you can't make your own decisions.
Yeah.
It's an act which applies just as much to, as it were, a professional as it were the person the professional might be engaging with. Which is one of the reasons I think it's so important people understand it, because it's not just, here's a thing about other people. Of course, if you're in a care context, it's a thing you need to know as part of your legal skill, as your skill set. But as a kind of wider idea of capacity and best interest, this is stuff which is about you just as much as it is anyone else.
Exactly, and I suppose some of the cases that come up are things we see might happen to all of us, like cesarean section cases, people who have phobias that might affect their mental capacity, people with schizophrenia or manic depression, or even if you've had an accident and you're on life support machine, all these things could happen to anybody at any time. So it's actually quite a fundamental piece of legislation that, like you say, could affect absolutely anybody.
Yeah, absolutely.
So understanding is crucial. Yeah.
No, I agree.
So in terms of how it's applied, you've got the principles to start off with, and if you could just talk through sort of very briefly what people using the Act would have to go through.
I think one of the really important things to understand about the Act is as you say, it's got this set of principles at the beginning. And most people don't sleep with lots of bits of legislation under their pillow. But if they did, and they looked at the different bits of legislation in the Parliament has passed, the Mental Capacity Act stands out because most pieces of legislation don't have a set of principles. They just get straight in with, like the Mental Health Act gets straight in. The first bit of the Mental Health Act says, this is what it means to have a mental disorder.
And it's the principle starts at the beginning with the
exactly,
mental capacity.
yes. And what's so unusual about the mental capacity is because it's got a set of principles at the beginning, they're there for a reason. Because the mental capacity act, as we were just talking about a minute ago, the mental capacity act could apply in almost any context at any time. And so, unless you've got a set of principles, which I always think of as a moral compass, unless you've got that, how do you have something which guides how you then do the actual thinking? So the principles, they're the 5 principles, and they divide into the principles thinking about capacity. So when you're thinking about someone's capacity, and then you've got principles relating to if the person doesn't have capacity, you've taken all the steps you can to support them to make their own decision, which is one of the capacity principles. If they don't have capacity to make the decision, how do you think about acting in their best interests? So they are, whenever I'm doing training or whenever I'm interacting with people who are having to apply the act in practice, it's the most important thing to come back and say, when I am assessing someone's capacity, say, and there's a statutory test for that, how do I internalise those principles? How do I apply them? And then when I'm thinking about best interests, how do I think about it? And if in difficulty, if in doubt, fall back and say, well, where's my moral compass here? So I think I think it's really difficult, or it's not difficult at all, it's really important to emphasise it. And I think but can I just emphasise one thing, having said that? The principles are the moral compass for applying the act. But if you're, for instance, having to work out, does someone have capacity, you have to apply the test of, does this person have capacity? Because one of the mistakes I do see, and the courts see, and we've also seen in sort of ghastly safeguarding adult reviews and things, is that people sometimes on the capacity side mistake the principle. For instance, there's a presumption of capacity, or just because someone makes an unwise decision doesn't mean they don't have the ability to make it. They take that and they say, oh, well, I don't have to think anymore. That's just what the test is. It's not. If you've got reason to wonder or doubt that this person's got the ability to make the decision, you actually have to apply the test. But in the back of your mind, you're going, I'm applying this test against the background of these are the principles.
But one of the things I wanted to ask you is, there's so many contentious things, but what do you feel are the most contentious or the most frequent issues that come up with mental capacity act? It might be the interface with mental health law, or it might be the functional test, or it might be best interests. But in dealing with providers, practitioners, people who are using it, either with the training that you do or questions that come up in cases that you know about, are there some things which people are just not getting right and kind of no-brainers where you think you just can't be doing this?
I suppose it's tricky. In terms of dividing it out, because there's some really no-brainer stuff like, why on earth didn't you record your assessment properly?
Right.
And if you've actually, that's just properly no-brainer, because you've not explained what steps you took to support the person to make their own decision.
Okay.
And you've not explained what the person can't do. What bit of information can't they understand, say? Why is it that you're saying that they can't use or weigh the information? So if you've not explained that, and you just say this person doesn't have capacity to make this decision, well, that's not a capacity determination assessment, that's just an assertion. And so that's a kind of complete no-brainer. And obviously you've got situations where, it's fast moving. In an emergency medical situation, please, if you're my treating doctor, could you not spend lots and lots of time writing up your assessment? Could you please just get on and treat me?
Yeah.
Assess my capacity, think about it, and then document it near, as close to the time as you can.
Yeah.
But, in other situations where it's slower moving, the recording is critically important. But that's a kind of, as it were, an administrative no-brainer. It doesn't mean it's not important, but it's an administrative no-brainer. I think the things which people find genuinely difficult, and I think the things where the areas get very contentious, are much more around, on the capacity side, it's much more around, in other words, does this person have the ability to make the decision or not? It's much more around the kind of the value clash. So in other words, I wouldn't make this decision.
Yeah.
Does that mean this person can't make this decision? And to be honest, it's actually, it's a phenomenally difficult thing to grapple with, because if you're in the caring professions, I would like to think that most people in the caring professions are in the caring professions because they care. And therefore, it's extremely difficult for people to, as it were, sit back and think, or not sit back, but take a step back and say, well, I wouldn't make that decision. That seems to be extremely risky, but that person might have the ability to make it. And if they do have the ability to make it, I can't step in and make it for them. It doesn't mean, of course, that you don't keep supporting the person and you don't keep offering help and you don't keep engaging with them, but you're engaging with them on the basis that if they've got the ability to make that decision, that's theirs. It's morally and legally on them, not morally and legally on you.
Yeah.
So I think the value clash bit can be very difficult. And I think on the best interest side, so in other words, on the person doesn't have the ability to make the decision, and then what's in their best interests. I think one of the things, and it's different in different sectors or different in different disciplines, possibly stereotypically, it can be quite difficult sometimes not to recognise that even though this person doesn't have capacity, we still know enough about what this person would want to do. It's in their best interests for X to be done.
Yeah.
This is most obvious actually in the kind of medical treatment side, and it's been interesting watching on the kind of last decade as how the courts have moved from much more, if the doctor says this is the right thing medically, therefore it's in the person's best interests, to, well, that might be, as it were, the clinical recommendation, that there might be a very strong reason why the person actually doesn't want that. Yeah. And not having the operation, for instance, someone with schizophrenia and gangrene who's saying, no, I don't want my leg chopped off, not having that may well lead to the person's death.
Yeah.
May well lead to the person's death. It just doesn't mean it's not in their best interests. And I do think one thing I want to really flag up here is, in some of these situations, and I come across this very routinely, people know absolutely what's in the person's best interests. They just know that if they go ahead and let this action happen, and the person then dies, or something bad, objectively bad, appears to happen, they are going to be hammered. They might be appearing before an inquest, and a coroner is saying, what on earth were you doing? You had the care of this person. The European Convention on Human Rights says the state has got a duty to secure people's right to life if there are practicable steps which should be taken, for instance, in the presence of suicide. What on risk of suicide? What on earth were you doing not doing something? And it takes huge shoulders to stand there and say, well, actually, I properly assessed mental capacity, and actually the person had the capacity to make it, or the even more difficult, I didn't think this person had capacity, but I didn't think it was in their best interests to impose X, Y, and Z. And I think some of the situations, and so the risk aversion side is not just, as it were, professionals being too risk averse for the sake of it. They've got real things hanging over them, which is why some of the court cases are really important, because the court's not there, or the cases have come to court, not because there's a fight, but because the professionals know what the right thing to do is. They just need a grown-up, in the sense of a judge, to say, I agree.
Okay.
And then if there's a brilliant case called M, which is a very useful name, but anyway, who was a woman with mental, just to give you an example, a woman with a mental health condition, I think it was schizophrenia, and very, very poorly controlled diabetes. So she's finding it extremely difficult to manage her diabetes at home. The clinical commissioning group who were looking after her do absolutely everything they can to support her in her own home, but she's just not managing her diabetes, so she doesn't regulate her food intake, her blood sugars are all over the place. And so they go, well, actually, we think the only thing we can do is put you in a care home. They really do everything they can, they think she doesn't have capacity to make decisions about managing her diabetes, she doesn't have capacity to make decisions about her medication, and she doesn't have the capacity to make decisions about her residence. So she's put in a care home. They recognise absolutely properly that she should be seen as deprived of her liberty there, because she doesn't have capacity to consent to being there, and also she doesn't want to be there. Actually, the mere fact she doesn't have capacity to consent to being there is enough, but they also recognise she doesn't want to be there. The system works because she gets an advocate who says she doesn't want to be here, and it goes to court. And the judge says, look, I am not criticising the clinical commissioning group here. They didn't really have any option except to do whatever they could to try and keep this woman alive. But I'm a judge. I'm allowed to do something different. And he says, ultimately, I've got to ask myself, essentially, what's the point? And M is described as being, the judgment says M is described being in his care home like being in a prison. And he says, ultimately, I've got to ask what the point is. And he said, the only answer I could give Em, if she asked me, is to keep you alive as long as possible. And he eventually says, well, that's kind of not good enough. And so there he says, well, in that case, I'm going to ultimately say it's just not in her best interest. It's not proportionate to keep her in this care home.
Yeah.
And so she goes home. I very strongly suspect she's not with us anymore. But I think it's really important to emphasise that was a case where I am absolutely sure all the professionals involved in the case knew really that the wrong thing to do was have her in a care home. But they recognised that if they'd just gone, okay, well, we'll let you stay in your own home at this massive risk, and then she dies, the coroner would have been saying at the inquest, you had the chance to save this woman's life, why didn't you?
Yeah.
So I think that's one of the areas where it's really just fleshing out this idea that sometimes there are societal pressures and other pressures which really do put professionals in a difficult position because they know what really the right thing to do is. They find it difficult to do it.
Yeah.
I would be less charitable in some situations. Professionals know exactly what the right thing to do is and just don't because it's too complicated, or it's too time consuming, or it doesn't suit administrative convenience.
Right.
So I'm not going to say that everything is always people trying to do the right thing, but I do think it's important to identify there are situations where people do know what the right thing to do is, but there are other pressures making that very difficult.
So one of the things that we do on our Coproduce Care chat is we go out to ask professionals and practitioners if they have any questions. So a lot of the questions I'm asking is based on things that they've asked me to ask you. So one of the things that a care manager asked was sometimes she's in a situation where she's assessed someone's capacity to do something, and then she might tell or just inform a social worker or another professional, a doctor, psychiatrist, and they disagree with the assessment. And the way that she said she felt was as if, I know this person, I see them every day, my care staff are with them, they know their routines, and we've done the capacity assessment as detailed as we can, and yet somebody else, because they're a professional with a different qualification, disagrees. But she feels that she's in the better position to make the judgment. So the question really is there a professionals hierarchy in terms of doing capacity assessments? That old adage, doctor knows best. But if you look at the code of practice, it's all about who knows the person and that person as a whole, how they were before their capacity was needed to be judged. So do you see a lot of conflicts between sort of like social care professionals and health professionals in terms of, or any type of professionals? It could be between an advocate, or it could be just a psychiatrist. Do you see those conflicts coming up?
Well, I suppose yes, I do, and I suppose that the thing is, then you have to ask, well, what do you do at that point, as it were? And it's going to sound a bit odd, but I remember doing a course before I got married, on kind of marriage preparation course, and one of the things that they talked about was, as it were, how you might resolve disputes which might come up.
Okay.
And one of the things it's always stuck with me is what you do is you imagine you're sitting on the sofa, the two of you, and the problem is between you, in front of you, and you're both looking at it and going, how do we solve this problem? And the analogy they use was it's like an IKEA flat pack furniture.
Okay.
Like, how do we make this together?
Yeah.
And I find it quite helpful to think of it that way, because it's not personal. It's not you versus, marriage preparation course, you versus your spouse, but here it's not one the care home manager versus the social worker. It's we've both identified we don't agree about whether or not this person's got capacity. Why don't we identify that? Right, let's sit down and think together about what is it. And this, by the way, goes exactly the same for best interests.
Yeah.
And so sometimes the process of sitting down and doing that goes, well, I've identified this, that when X says this, or when they do that, well, I've recognised over time, because I see this is entirely in keeping with them. And that might be a piece of information, for instance, that the social worker say, or the doctor, or the person who may come in and see them and not know them as well, will go, oh, well, I didn't realise. Okay. Do you see what I mean?
Yeah.
And actually, it may make all the difference if you go, well, I didn't realise that was something which was completely out of keeping or completely in keeping. So it's like a data point.
Yeah.
So I think as in terms of strategies for, as it were, resolving, it's really the idea of, well, why don't we agree? Let's sit down together and go through and think about it.
Yeah.
And so I think that's really important. I think the other thing I'd say is that there is a hierarchy, or there has been a hierarchy in the courts once upon a time, that a psychiatrist knows best because capacities in some way was perceived as a kind of psychiatric thing. And then anybody else rather lower down. It's absolutely not the case now. The courts, what they want to know is, like the Code of Practice says, who knows this person best? I mean, obviously, if they know the person best and haven't got the first idea about the mental capacity act, then that's kind of irrelevant. But if you can show that I understand what the mental capacity act, I've internalised the principles, I understand the test, then blindingly, obviously, familiarity is going to be important. Because at the end of the day, mental capacity assessment is just a conversation.
The only caveat I see to that is thinking about what you said before and the different pressures on different people.
Yep.
You have a professional who's not part of the not part of the team that the registered manager's from, and they've got the different pressures on them to make sure that the right decision is made. So they're almost coming from a different positionality. So the registered manager is thinking, well, I've got my team, I've got the evidence, I've spoken to the families, it's fine.
Yeah.
But maybe the professional is thinking, well, I need to if I get this wrong, there's so many ramifications, that they're thinking more in a risk-averse way because of those pressures.
They might well be, but I mean, again, that would be one of the things, just as it were, sit down and work out.
Okay, yeah.
If you see what I mean, it's why have we reached these different conclusions?
It's like having a dialogue there.
Yeah, and it's immediately recognising we don't agree. Well, let's work out why we don't agree. Not we don't agree, therefore I am right and you are wrong. Either way around. I mean, I think the one thing I would say is there are some situations where somebody somewhere is going to have to make a decision about whether or not this person's got capacity to make a specific decision. So, for instance, the doctor who's going to carry out a procedure, they themselves need to be satisfied before carrying out the procedure this person has or lacks capacity. They are the decision maker there, so it's them who has to be satisfied. There are other situations where it's more, as it were, diffuse, and it might be more people might have an interest in knowing whether or not the person's got capacity. But it always comes back ultimately to why capacity is important for purposes of the Mental Capacity Act in the context that we're talking about. It's all about the fact that the Act relates to individual acts of care and treatment, and ultimately it's actually about providing protection for the professional carrying out an individual act of care and treatment. Because if I touch you without your consent, not in any dubious way, just to carry out care and treatment, if you don't consent, technically I'm assaulting you. But if you can't give consent because the impact of your dementia, or you've got very profound learning disability, or you're unconscious, what the Mental Capacity Act says is so long as I reasonably believe you lack capacity, and I've taken reasonable steps to establish that, and I reasonably believe I'm acting in your best interest, I am protected. That's actually, when you get down to it, that's what the Mental Capacity Act is doing. And so who needs to have that reasonable belief? Sometimes actually you need to take a step back and say, well, who is actually needing to know this? And it's also, I would just flag up, slightly muddied by the fact that, for instance, if we're talking about someone who's getting publicly funded care, when you're thinking about the assessment of needs and the supporting of people's needs under, for instance, the Care Act, that's not actually governed by the Mental Capacity Act at all. You're having to think about someone's capacity to engage with the process of assessment, but it's not ultimately capacity based. It's what are these persons' needs, how are we meeting them? The Mental Capacity Act it sits alongside it, but it's not actually governing it. And it's quite often some of the tensions, when you really unpick it, are down to people being slightly unsure as to precisely what role they're playing. Right. So, for instance, the care home manager you were talking about in your question, and the social worker, what I'd want to know, if as it were I was the marriage counsellor, you know what I mean? Yeah. If I was the mediator in that, I wouldn't even want to characterise it as a dispute. As the mediator in that, or facilitator of that discussion, one of the things I want to know is, well, why do you, social worker, need to be, what is your interest? Why is the reason you're concerned about this person's capacity? Care home manager, what is it what aspect of capacity is engaged here, and why is it your responsibility? And one of the things with the mental, it's reminding me that the Mental Capacity Act Code of Practice is under review at the moment. Yeah. And I'm involved in it, and one of the things which is really tricky actually when you start thinking about it is our Act is very firmly not characterised as giving proxy decision-making powers to one person.
So actors would be people using the Act.
Yes.
Yeah.
So what I was just going to contrast it, but there's some countries where if you don't have ability to make a decision, it's automatically granted as a matter of law to somebody else.
Okay.
So many states in America, for instance, if you're unconscious or you're needing medical treatment, you don't have the ability to make that decision. That power is automatically given to a sort of a statute list of people, your family.
It's automatic substituted decision
It's automatic, yes. So the doctor would just talk to your wife, your husband, your father. I mean, there's a sort of, mother, there's a list, and they would be making a decision. The Mental Capacity Act doesn't work like that at all. It doesn't have, in the event that someone doesn't have the ability to make the decision, it is down to one nominated person to make the call, which is both brilliant, because it doesn't, as it were, automatically allocate decision-making responsibility to somebody. It's also quite problematic, because it starts filtering into the sort of area the care home manager's flagged up, that sometimes you aren't quite sure who has got responsibility for thinking about someone's capacity and best interests, who's actually accountable, who is the decision maker. And so the next iteration of the Code of Practice, I think, is going to have rather more detail on how you actually unpick it. Right. Because the idea of the collaborative thinking about capacity and best interests is brilliant in the abstract, but it then sets people up for going, it's my job to think about it. No, it's not your job, it's my job. And then you get these rather unhelpful tensions. But I would just to reinforce the fact that it's going to be down to, assuming you both can say you know the law. Like, if you don't know the law, then, obviously the person who knows the law is operating the right framework, is going to, as it were, be stronger. If you both know the law, then whoever is going to have the best ability to work out capacity is going to have things down to familiarity, people skills, time, things like that. I know it's a brilliant case to give the example of how there's of this in practice. There's a case called FX, as in special effects, but which is the initials of the person, about a young man with Prader-Willi syndrome, so learning disability and Prader-Willi syndrome. And I'm sure you know Prader-Willi syndrome, one of its manifestations is a total inability to control your eating, and you will just eat yourself to death. And so the question was, it arose in a specific context: did this man have capacity to make decisions about his care arrangements? And the leading expert in the country, a wonderful psychiatrist, academically brilliant, been studying this for years, goes to see him, and he just doesn't want to talk about Prader-Willi syndrome. He just won't engage. And the expert says, well, I don't think this man's got capacity to make this decision. His social worker goes to see him. His social worker provides evidence to the court saying, well, actually, the problem is he's just really embarrassed.
Okay.
And she found ways in which to get round that embarrassment and engage with him. And so that could be just as much, as it were, the social worker might come in as the expert, as it were, see this person one off, versus the care home manager who knows how to get round, that embarrassment. So I'm not saying it's doctor equal, doctor above social worker above care home manager. I'm simply saying, when it comes down to it, it's that engagement and the conversation which is the critical thing.
And I think it's really important to hear you say that, because I think sometimes you'll have somebody who works in the social care sector and they'll have a professional come along and they automatically, from discussions I've had with people, start to doubt their assessment or doubt their ability to do it, because they think, well, this other person has a different type of qualification, maybe they're better placed to make the assessment. But actually, like you say, if you know the person, if you know the law, you know the person, you've got your evidence, you've written about it, you've done the assessment, and also you know how to communicate with that person, because they could lack, the communication, not being able to communicate their decision, simply because, like that person in that case, they didn't want to talk about it, but an outsider doing that assessment might not realise that. So it's almost, it's really like, I think it's represented quite nicely in the Code of Practice. There's a lot of people who could be involved in it. I suppose practically people would say, time, resources, but in an ideal world, that would, I suppose, be the case. Yeah.
But also, I think it's really important, if there's a disagreement, take a step back and try and identify why it is that there's a disagreement. And it may find that disappears. But ultimately, if there is not agreement about whether or not this person's got capacity, you can't just rampage ahead on the basis that they either do or don't. There is genuine disagreement.
Yeah.
And the only place you can get an authoritative determination, does this person have all that capacity to make this decision, is the Court of Protection.
Yeah.
Everybody else is operating on the basis of reasonable belief.
So, moving on to the Court of Protection.
Yep.
I read an article that I think you and some others did about looking at how decisions are made there, and a case of, I think it was King's College case, came up and talked about judges saying, we need to think about our own values when we're doing capacity assessments, which we kind of touched on before. And I'm just wondering, in light of that, when we're doing these assessments, do we, as assessors in the profession, need to do our own critical reflective practice to think, well, what might affect my assessment of this person? Am I, putting too much on the fact that I just don't agree with them? Because in most cases, an issue will come to the Court of Protection because the person disagrees with the professional or with the advice that someone who thinks they should agree with them has come up with. So, I would like to hear your views a bit more on that case.
Yeah, just for people who don't know it, it's a tragic case in many ways. It's also, you could also portray it as a very important case upholding someone's autonomy.
Yeah.
And I would just also, you may or may not know in this context that autonomy, the concept of autonomy, originally came from the ancient Greek of people choosing how they died. Autonomy is not necessarily a sort of group hug, cuddly, positive outcome.
Okay.
It was about, I am dying, or I'm in a very difficult position, how do I secure my own end?
That puts a different spin on it.
I think it's really, but I think it's really important to understand that, because autonomy is generally seen as let the person do what they want and it will be all good. Whereas this was, for instance, Socrates deciding, faced with a situation, a very difficult situation, and he was going to be prosecuted, he got the opportunity to say, I am going to end it myself by drinking poison.
Right.
This is my control. So I just think it's, just in terms of autonomy, is not always, as it were, good in the sense of for other people around the person. But in that case, the King's College case, that was a woman who really was, from the case report, quite an unusual person. She'd led quite an idiosyncratic life. Everyone's idiosyncratic, but this was particularly self-centred. And she was very, very concerned about her looks, and she was very concerned about living a sparkly lifestyle, as her children described it. And she gets cancer, and she's also facing prosecution for a domestic abuse incident at the end of a relationship. And this just isn't how she sees her life story ending. So exercising what she wanted to perceive as her autonomy, she goes down to the beach with a big bottle of pills and a big bottle of champagne, and that's how she thinks her life story is going to end.
Okay.
It doesn't, and she's in the intensive care unit in King's College Hospital in London, and she needs dialysis. With dialysis, she's going to live. Renal dialysis, she's going to live, because it will sort out the effects of the overdose. Without dialysis, she's going to die. And this is, by the way, a classic example of a situation where it would be wrong, it would have been utterly wrong for the medics to go, oh, well, there's a presumption of capacity and there's a right to make unwise decisions, therefore we won't interrogate her refusal. Because if she'd died at that point, the coroner would have said, well, you had this person, there was something you could have done, why didn't you? So the presumption of capacity is kind of interesting there at that point, but not where there's reason to doubt.
Yeah.
And so they looked very carefully, and they said, and ultimately they said, well, we're not sure whether or not she's got capacity to make this decision. We don't think she does, because we think she is incapable of using and weighing the information that with dialysis she will live. She simply can't visualise a world in which she is alive. She's just, this is not bloody-mindedness, this is overly concrete thinking. She can't do it, and we think it's because of narcissistic or histrionic personality disorder. They recognise that that's quite an edgy thing to be saying, because she'd never been diagnosed with that, and it sort of seemed a bit convenient for that suddenly to appear. But they did the right thing, they went to court. And the judge said, I think she has got capacity to make this decision. And it's quite a long judgment, but if you read it, what really comes through is him saying, you need to differentiate between someone who can't use and weigh information, and they can use and weigh information, but they're just doing it according to a very different value set.
Yeah.
And the vital bit of information for him, it appears, was the evidence given by her daughters, who said, look, we really hate the fact that this is what our mother is saying. You know, we love her, we would like her to be alive. But this is just the sort of, I think they're almost exactly the words they use, but the kind of ghastly, self-centered thing she's always done. This is just who she is.
Right.
And so the judge effectively said, well, I can't. This is just who she is. This is just a person applying a very, very different value set. He's not unable to do it, he's just doesn't want to.
Yeah.
And so he said, well, I can't interfere if she's got capacity to make this decision. I'm not going to override that, I can't. And the medics can't override that. And then she died, she refused treatment, and I think she died 2 days later.
Okay.
And I know it was because I work with medics from King's, it's still listed them.
Right.
You know, so but it doesn't mean it's. People watching this can make up their own mind whether they feel it's right or wrong.
Yeah.
But as a process for thinking it through,
Yeah.
it can't be faulted, as it were. And they really did think very, very, very carefully. And I think going back to the values point, the two learning things I always get out of it are in the dispute case where, I mean, some cases it's what's really the problem is it's fairly obvious the person just can't understand the information.
Yeah.
Well, that's really, that's not really open to debate frequently. They can't retain the information. That's quite, it's not really open to debate.
Yeah.
Or they can't communicate their decision. And if you try to find ways to help a person communicate, they can't do it.
So those are the functional.
Yeah,
parts
those
of
are the bits.
test.
They are generally less open to debate one way or another.
Yeah.
You might have a debate about how well you're trying to communicate, but it's not really open to debate. The bit which is really open to debate or feels controversial are the ones where you're saying, well, this person can't use and weigh the information.
Okay.
And so what was really coming up for me was from there was you can't make that decision unless you've worked out what the person's values are. Like, where does this decision sit in their life story? Is this completely in keeping? This is completely out of keeping?
Yeah.
And then, as you were saying, it goes back to what's my own value set?
Yeah.
It doesn't mean that the mere fact that they wouldn't make the decision that you would make doesn't mean that they either have or lack capacity, but you need to be aware of, how risk averse, how risk tolerant am I?
Yeah.
And different people just have different levels of it. And it doesn't mean it's automatically right or wrong to be more risk tolerant or more risk averse. That's not neither here nor there. You just need to be aware so that then you can gauge.
Yeah. It can be quite complicated, but if you're thinking about your own values, that helps. Is there anything else that proactively people can do to understand the values of the people they may have to assess in the future, to help them better be able to think, well, what would that person have wanted?
Yes, I mean, I think one thing I would just emphasise before saying all that, the sort of cases we've been talking about just now are in the minority, in all honesty. I mean, I tend to think that most capacity assessment, probably 85%, are really perfectly straightforward.
Okay.
And the only reason they're not straightforward is you haven't got time to do them, which I'm sympathetic with, or you're not listening, in which case I'm not sympathetic.
Yeah.
But there is a cluster of cases which are more complex. So I don't want people to get the impression that every single capacity assessment is incredibly difficult. No, it's not.
Yeah.
And obviously, the depth of needing to dig into something is going to also be calibrated according to the gravity of what the thing you're worried about is. What does someone have to have for breakfast? Is it a different order to, do they have a life-sustaining treatment decision made? I mean, it's so I just want to sort of frame that. But I think one of the things is, in terms of thinking about, on the values side, if we're talking about, we need to be differentiating carefully between values in terms of thinking about capacity assessment. So this is about thinking about, what does this person have this ability to make this decision or not, or I really don't think this person's got this ability to make this decision. What's in their best interests? Because obviously values feed into both. Because the values might help guide you as to whether or not you think the person's got capacity to make the decision, but also they're going to be massively important in thinking, well, even if this person doesn't have this ability, what would they do? Then that can give me a steer as to what's in their best interests. It's not as simple as, oh, well, I know what they would have done, therefore I do it. Because the best interest test does say, well, I've got to take a step back and say, overall, is that in their best interest? But I mean, really, it's just good social work practice. It's good care practice. I'm putting a legal framing on it, but I mean, this is just getting to know the person you're working with and getting to know, if there's input you can get from a family member, say, or, if you can if it's an older person finding out what they did in the war, that what they did with their life before, for instance, the onset of dementia, or is that sort of stuff that, and that's really just getting to the sort of personalising care that one would want to be thinking about it anyway.
Yeah.
So I think one of the things I always get slightly stressed about is when someone like me turns up and says, "Hello, I'm a lawyer," people go, "It's the law." And actually, sometimes what needs to happen is you go, no, what I'm telling you to do is frame stuff you are already doing,
Right.
and recognise that what you are in fact supporting this person to take their own decision. And actually, you are doing all of this stuff. You, as it were, didn't realise you were doing it.
Yeah.
I mean, sometimes, of course, you have to, as it were, give a mighty kick to someone and say, no, actually, this is, shift.
Yeah.
But so much of the time, this is just doing what you would want to be doing with working with people anyway.
Yeah.
And then recognise it, actually, that's helping me then guide my thinking about capacity, my thinking about best interests.
And I think that helps because if you're giving good care, if you've got good care plans, if you've got good records, if you've got a great relationship with the family, if they have any family, you're doing all those things anyway. So when it comes, I think, because it is a legal, it's a statute, and there's a lot of law around it, there's a lot of case law that's developing, it does feel really scary. But actually, like you say, if you know someone really well, you probably are best placed to use the evidence that you have anyway to help inform your decision.
Yeah. No, I agree. I mean, as I said, there are obviously a core of things, where it's particularly risky or the consequences are particularly grave that, you then have to, as it were, really make sure you've dug into.
Yeah.
And there are going to be cases where there just is a straight punch up, which shouldn't be a punch up, as we've explained, as straight, identification of a disagreement and working out how to resolve that.
I would like to hear a little bit more about the project that you're undertaking at the moment. So you're doing some research around, I think it touches maybe on values or how people are applying it in the court of protection. If you could sort of talk
well, actually,
about
sort of two different projects at slightly different stages. The one which is rather further ahead is one called Mental Health and Justice, which is run it's been led out of King's College London, but it's in various different settings. And that one is, as its name suggests, is about mental health and justice very broadly conceived, but it's got multiple different work streams underneath. And then one of the work streams that's particularly relevant to what we're talking about today is one on difficult or contested capacity assessment. And it's recognising that we're talking about the 15% of cases, not the 80, it's not across the board, it's all incredibly difficult, but they're recognising there is a group of cases where there are things which make it more complex.
Okay.
And it's identifying some of those complexities really are things which can't just be got rid of by saying have more time.
Yeah.
It really is more challenging. And it's trying to recognise that if that's the case, what sort of tools do people need in order to achieve more successful determination or more transparent and more accountable, actually. We initially started off saying better, and then actually that's not really the right word. It's more transparent, it's more accountable. And so it's been doing work, for instance, looking at how the Court of Protection has resolved those disputes.
Okay.
It's been building on that with interviews with practitioners, interviews with judges, which I can't really get into too much at this stage because that work isn't published. But it's building up, in particular, one of the things it's really struck me working on it, because I'm a practicing lawyer, I'm also an academic, so I sort of see the two sides, and I spend a lot of time working in multidisciplinary settings. And one of the things that's really struck me is there is something of a gap between the law, when it's in the Mental Capacity Act, for instance, use and weigh, and what people are actually seeing when they're encountering people.
Right.
And one of the things which is terribly interesting, I find, is if you ask X number of people, which we did, what does use and weigh mean to you, you more or less get X number of different answers.
Yeah.
And I think that doesn't help in terms of making sure that you've got, on the difficult cases, where they do have sometimes a feeling of arbitrariness, in all honesty, that how do you then say, well, this is how I made it, this is how societally this feels like a more acceptable resolution.
Yeah.
And I think one of the things we're really working on, and it hopefully will be out quite soon because it's reasonably close to publication, is identification of there's clusters of things which people just seem to be unable to do or able to do. For instance, not being able to appreciate risk. That's a thing which happens sufficiently often that you can't just say, well, this is just some imaginary phenomena. Like, this is actually a real thing in some situations. Well, that's fine, but how do you, as it were, say, well, that person can't appreciate risk. Well, what do you do with that piece of information in terms of saying, can this person make the decision or not? Because Mental Capacity Act says understand, retain, use or weigh information.
Yeah.
It doesn't say appreciate risk.
Yeah.
And like, well, how do you think about that? So the work we're doing is sort of thinking about, well, how do you, as it were, how is that bit of, as it were, real phenomena that people come across? How do you actually coherently say this relates to the mental capacity? Or another one which comes up the entire time is insight. Because insight doesn't feature in the Mental Capacity Act at all, legally. Insight is used day in, day out in mental health contexts. It's also used day in, day out in all sorts of situations. So if this person doesn't have insight into their care needs, well, kind of, so what, legally? But if it's a thing which people are thinking, I mean, either everybody's wrong, or actually it's something which people recognise, but how do you actually say, well, that relates to the law? So it's sort of a funny sort of way, it's almost like a translation piece of work.
Yeah. Where do you think, because I've seen in a lot of cases that, I think it was from the medical profession, I might be wrong, the word insight come out a lot. Where does that come from? Is that because that's part of when people are diagnosing people, that comes from there rather than from judges or any part of the case law?
It can't. I mean, psychiatrists are familiar with the concept of insight because it's quite important clinically. If you're thinking about it, traditionally it's been important clinically thinking about it in the context of potentially detaining someone under the Mental Health Act, because if you don't have insight into the fact, for instance, you have a serious mental health condition, that is a red flag for a psychiatrist thinking, do I possibly need to make out a medical recommendation to detain you?
Right.
But it's a word which is edgy, and it's known, but even in that context there are people who have slightly different ways of thinking about it. And actually one of the other strands on the Mental Health and Justice Project is really digging into insight and how it's used and how it's not used.
Yeah.
But what's interesting is that judges who aren't trained medics, they will quite often, in their judgments, even when no one has used the word insight to them, use it themselves. And so one of the things is ultimately coming up with I'm not saying just because we say it doesn't mean it's right, but it's having done an awful lot more work than a lot of people have done to really flesh it out and think it through and see how these things are being talked about in different contexts, and as it were, bring them out to the light, and then stress test. And one of the things on the project is we have got a very strong service user advisory group who we can stress test this with a group of people who are either themselves or family members, but in particular the service users, who might be at, as it were, risk of having this deployed on them. And so it's not just, as it were, a group of academics and lawyers who are all, cognitively apparently unimpaired and are perfectly unlikely to have the AMCA deployed on them anytime soon. This is with people who you can look at it. And then also, if it's brought out into the open, you can then have a debate more generally about, well, if this is what people are saying the whole time, are they just all wrong? Or are actually these are things which are real phenomena in terms of people being unable to do in some situations? And if they are, well, how does that then help us think through at a more gritty level? How do you then support someone?
The only, I suppose, like you said, insight isn't mentioned in the Mental Capacity Act. How would you support people if that word was useful? Is it something that you could then think about? I don't know how far along the Code of Practice is in terms of its review, but would you then have to change something in the Code of Practice, either in terms of insights that you mentioned, or in terms of use and weigh, and just having more descriptions to help? Because that's, I suppose, when you're thinking day-to-day basis, that's the document that people use. The Code of Practice, you probably turn to that first for the detail on how to apply the Act. So is that where it would be easier to change Code of Practice?
Yes. Well, I think one of the things, and I'm having been working on the Code of Practice for some time now, and on the associated Code of Practice for another bit of the Mental Capacity Act which is coming into force. Actually, codes of practice they've got quite a limited function. They're not really, weirdly, actually the practice guidance for people as to good practices how to do things. What they're really trying to do is flesh out what the law means, give more practical examples, but they're not really saying this is how you do a capacity assessment. So, for instance, there's nice guidance on capacity, decision-making capacity, which is Bits of it are very good, bits of it I have slightly more problems with, but that's more where one is going for the sector-specific, how I think about capacity assessment in the context of X, Y and Z.
Okay.
And in different organisations like the British Medical Association have got it for doctors, you've got various other, British Psychological Society, you've got good stuff for psychologists, you've got different things for different groups explaining how the law applies to different organisations or different groups of people. So yes, you're right, people turn to the code of practice, but you're never going to find in the code of practice, it's all about at quite a high level of generality.
Right.
And I think on insight, already the NICE guidance says, one thing you mustn't do is say, this person doesn't have capacity because they don't have insight into their condition, because it doesn't make any sense.
Yeah.
What you have to do is explain how you get from, I don't think this, someone has told me, or I don't think this person's got insight into X, as to how you translate that into, that means this person can't understand the information, or this person can't use and weigh.
Yeah.
So and the NICE guidance already says you've got to be careful to, as it were, make the case.
Yeah.
And I think so again, it's always about making the case, why, and explaining. Like when we right at the beginning, you said what's the kind of most rookie error, or the most obvious barn door obvious thing. The most barn door obvious thing is not explaining how you reach your decision. So it all comes back to. So I'm not saying insight is, as it were, something you're not allowed to think about, or if someone tells you, I can't do anything with that. But what you need to do is either, if you're the person doing the assessment, explain it, or if someone else is telling you that and it's their assessment, go, well, can you explain to me how? Like, what are you actually meaning in terms of the mental capacity yet?
I'm going to move on to our cactus question now. And for anyone who doesn't know what our cactus question is, it's our prickly questions about health and social care. So we have our resident cactus here, which is really super cheesy, but we're going to go with it anyway. So the first cactus question that we've got for you is, which I think we're probably going to be asking everybody this, how do you think Brexit might affect your area of law, if at all?
It's already having a massive impact on us, because Brexit, followed by the election, has completely stalled people actually doing work that they need to do legislatively on, for instance, updating the code of practice, on thinking about liberty protection safeguards, which whole aspect of the law which is being thrown into disarray because when the election's up and running, this being November, they're limited on what government can do. Yeah. So the very fact of Brexit is having a big legal, for my sector, is having a big legal problem, and then of course it's going to have a massive impact on the actual workforce, given the number of people we rely on who, depending on what happens in terms of Brexit, it's already started to decimate the workforce. So yes.
Yeah, I think that's pretty much the standard answer for everyone.
Yep.
It's going to have an impact, and it's not going to be good. So another question is, there is this international human rights thing called the UN Convention on the Rights of Persons with Disability. I'll start again. The UN Convention on the Rights of Persons with Disabilities, shortened to the UNCRPD. So the UK signed up to that in 2006, and they have a committee that comes out and inspects member states, and members who have signed up to it obviously will know about everything about this. And they came along to the UK, I think in 2017, and said that we weren't compliant with a lot of parts of the UNCRPD. And one of the things that they say is they have an issue with the Mental Health and the Mental Capacity Act. So, in light of that, should the Mental Health and the Mental Capacity Act be abolished in light of it not being compliant with the UNCRPD?
Can I park the Mental Health Act entirely?
Fine.
I think just, as it were, it would be easier just to think separately about the Mental Capacity Act.
Sure.
I think and just to emphasise what's incredibly important about the UNCRPD for people who don't know, and every time I do training, only about one person's heard of it. The reason no one's heard of it is it's not like in part of our law like the European Convention on Human Rights. So I can't rely on it in a court on behalf of a client to say that their rights under the CRPD have been breached. It's us as a state signing up to this convention. And because it's not part of people's day-to-day practice, that's why they haven't heard of it. But for people who aren't familiar, what's incredibly important about it is it's very strongly based on a social model of disability. So there just is not such a thing as disability. There are impairments, and society isn't responding appropriately to those impairments, which is frankly impossible to deny. where it gets tricky in the mental capacity context is the CRPD itself doesn't actually say you are not allowed to have legislation which looks at the Mental Capacity Act. The Committee on the Rights of Persons with Disabilities have said they are very uncomfortable with the idea of mental capacity because it's basically arbitrary and it pretends to show the workings of the inner workings of someone else's mind.
Mm.
Now, you may think, based on everything we've just been talking about over the past, half an hour or so, that's difficult in some cases not to think that there's a distinct grain of truth in that. And they also say they're very uncomfortable with the idea of best interests as we have in the Mental Capacity Act, because we will in some circumstances go, we know what the person wants, we won't do it. And so they've said, please can you move away from the idea of mental capacity, and can you please essentially make any decision in relation or for someone with a disability must always follow their will and preferences. And so in other words, everything must always be done on the basis that this person has in law the right to make a decision which must be respected by other people. I think the reality is the UK is not going to do that. The UK won't say we will abandon completely the idea of mental capacity and we will abandon completely the idea of best interests. I have spent an awful lot of time working on this in this area, and I think one of the things I would emphasise is I think even the committee themselves are now going, actually in some areas it's really complicated. And for instance, they in last month, in October 2019, they examined Australia. So they examined us, as you mentioned. They examined Australia and they said, Australia, could you please adopt law reform proposals from the Australian Law Reform Commission, because they represent what we think should happen. Now, interestingly, the Australian Law Reform Commission proposals are based on the idea that some people, in some circumstances, you cannot support to make their own decisions. So it looks like a functional model of capacity like we have here. And the Australian Law Reform Commission also says what you normally want to do is follow someone's will and preferences, but to respect a person's rights, will and preferences, which is what the CRPD says, there may be some circumstances where you don't. You have to take them into account, you have to think very carefully, but it's not always the case. And they are like, for instance, on the case, the sort of hard case that they flag up are things like that someone with anorexia who says, I don't want to die, but I'm refusing to eat. And I think one of the things why we won't, I suspect, abandon it is our Mental Capacity Act, and it's not perfect at all, but it does actually provide a way, if it's taken seriously, especially with support, to try and support people to take their own decisions. It doesn't just go around, as in some other jurisdictions, saying you appear to have some mental health condition, we're just going to say you can't make any decisions. So we try and do that. It doesn't always perfectly, we try and do that. And then our model of thinking where someone lacks capacity, if it's done properly, is, I would say, respecting someone's rights, will and preferences. It is trying to work out what the person would have done and trying to follow that unless there's a very good reason not to. And the very good reason is almost, the legitimate good reasons are, for instance, what you really want to do is live, but what you're currently saying is going to put your life at risk. So it's a very long answer to the cactus. I'm sorry, cactus. But it's what's brilliant about the UNCRPD committee stuff in this area, and they're concluding their assessment of us. It's a massive kick up the backside for people who were very complacently saying, well, the Mental Capacity Act is world leading, everyone should adopt it, because we did, in a very colonial fashion, go around telling everyone that's what we should do, they should do, because we were brilliant. And it's saying, well, no, I'm sorry, actually there are big chunks of it where, no, this is actually can be used as a tool just to ignore the rights of people with disabilities. But I think the way it can work and the way we've sort of been talking about it, you can see in different contexts, not the whole time, but it's capable of being a piece of legislation which responds to the fact in some situations some people simply are unable to make a decision. And not to do anything at that point would effectively be to leave them to die with their rights on, which would be, I think, just frankly societally and morally unconscionable. And then in terms of thinking about decision making, actually try and really balance all of these things.
So it might be, in a way, even though a lot of people don't know about it, getting to grips with it, understanding what it is and the ethos behind it might be quite useful in trying to unpick how we are supporting people, just to understand
Absolutely.
the UNCRPD, what
Yep.
it is, how it might apply.
Yep.
Yeah.
It's
okay.
hugely important for people to get to grips with, and it really helps people, I think, sometimes thinking about, well, for many people, thinking about will and preferences is actually a much easier way of thinking,
Yeah.
because they can go, I know what this person, I know their will is that they want this, but what their preferences they're currently expressing are just getting in the way of it.
Sure.
Obviously, if you're applying the law in England and Wales, you're working in England and Wales, you have to apply the Medical Capacity Act, but it's a really helpful way of thinking.
Yeah.
And to reinforce what social workers know, what care workers and care practitioners already know of the social model of disability, which is what we're trying to do, is support people
Yeah.
to ensure that their impairment does not become a disability.
Great.
So
Okay.
yeah, it's a hugely important piece of legislation. I part company with the committee at the outer edges.
Okay.
And even the committee themselves, I think, are actually going, you know what, I think they're beginning to shift and saying, we recognise it's in some of the really harder areas, this, you know, a model which is not a million miles off this is the best way to achieve that outcome.
Yeah, and essentially the actual convention itself doesn't say what the committee kind of takes it a step forward.
Yeah, and as I think it's important to understand, the committee is, I think, almost every person on the committee at the moment, and traditionally has been a person with a disability.
Okay.
So these are people with disabilities, not necessarily cognitive impairments.
Right.
There's one member at the moment who has intellectual disability. Previously, I think they were all physical disabilities. But still, these are people with disabilities saying our human rights are not being respected, or what are notionally human rights enjoyed by everybody simply aren't being respected because society is not providing basic support to allow us, for instance, to enjoy a right to liberty on the same basis as everybody. So it's a massively important wake-up call. And actually, when I was teaching at King's College London, I teach a course on mental health ethics and law, and we were doing one aspect of this the other day, and what I was saying was, for health and social care professionals, it's really important if they see it, they grapple with it, and they engage with it, and then work out if they part company with it, what's the point at which they part company and why, and that's massively revealing for people as an exercise to think about, well, what is it?
Yeah.
And it might be, in some cases, this might push them to being more, oh gosh, I've got to do more support, or actually this is, push my risk tolerance.
Yeah.
But it's, I think, again, going back to this whole business running theme of self-awareness,
Yeah.
but please, you have to apply the Mental Capacity
Yes,
Act if
of
we're talking
course,
about
the law
Mental
is the
Capacity
law, right?
Yes, but this doesn't mean it's not a really important thing to know about and be engaged with the debate.
Yeah, okay, thank you for that. That's been absolutely fantastic. Taught us so many things to take away and think about and consider. Thank you so much. So I always ask people at the end, if someone watching this wants to know more about you, wants to read what you're doing, is there a blog or Twitter, or are you on social media that we can read up about what you're doing?
Probably the easiest is my Twitter handle is a
Yeah.
ghastly thing. But anyway,
That's fine, we'll put it all in the description.
Yeah, at Capacity Law,
Yeah.
and then that's probably the easiest way
And
to
you've got
follow.
a blog as well?
I do, yes, mentalcapacitylawandpolicy.org.uk. But it's a
Okay.
bit of a mouthful, so at Capacity Law you will find
That's
it
fine,
there. So,
we'll put it all
yeah.
in the description in this video, so you're okay. They'll be able to find you.
Good, good.
Thank you so much, Neil.
My
It's great
pleasure.
having you.
Thank you.
Thank you.
Thank you.